My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, a program I started in 2019, I'm going to be discussing how to choose which petition you need when filing for a dissolution of marriage. Family law is probably the biggest category of law that touches the most people. Now, the stats vary, but a very large percentage of marriages end up in divorce. Some say upwards to 50%. So, if you or someone you know is going to get divorced, the good thing is that it's completely possible to proceed without an attorney. Now, I'm not saying that's the best way to proceed, but with the Florida Supreme Court approved standardized forms that I'll talk about here today, it is completely possible. So, the forms. If you Google Florida Family Law Forms, you're going to find the link to the Florida Court's website. On that website, you're going to find all the necessary forms to file for a divorce. But if you scroll through it, you may get overwhelmed, which is completely understandable. So instead of identifying which petition and all of the supporting documents that need to be filed, you could just go to the clerk's office and purchase the packet, which will include all of the supported filings. So say you do that, you go to the clerk's office, but you still need to know which packet is right for you. Now, I will discuss a summary here, but I strongly encourage you to open up each type of petition and read the section that's titled, "When should this form be used?" If there are no children, the wife is not pregnant, you've divided all assets and liabilities, both spouses are willing to sign, willing to waive alimony, waive a right to trial and appeal, and appear at the final hearing, then a simplified dissolution of marriage will work. The biggest reason why I see a simplified dissolution of marriage not being successful is that one party is not willing to appear at the final hearing. So you've got to both be willing to appear. A petition for dissolution of marriage with no dependent or minor children or property is going to be appropriate if there are no children, one or both parties are seeking alimony, you both want to participate in discovery. Now, to me, the most practical reason to file this type of petition is when one spouse is not willing to cooperate with appearing at the final hearing. Only the petitioner is required to appear at the final hearing in this type of case, assuming there's no counterpetition. The next type is a petition for dissolution of marriage with property but no dependent or minor children. Now, this is going to be appropriate when there's no kids, but there is property or a party is seeking alimony. Oftentimes, these are resolved with a marital settlement agreement, which I'm going to address in its own Scales video. The last type of petition is a petition for dissolution of marriage with dependent or minor children. So that one's going to be necessary when there are children involved, whether you have property to divide or not. Today has been a broad overview about which type of petition to select for a dissolution of marriage and figure out which one is the right one to file. If you found this information useful or you know somebody that could benefit from it, please like and share and follow the campaign's social media. If you have a particular topic you'd like me to address, send a message through the campaign's social media or website, and I'd be happy to film a video on the topic. Just remember that I can't talk about a specific case or specific facts, but I can speak in an educational manner. If you miss an installment of Scales, visit the campaign website to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.